appeal in the matter of Alize 1954 and another, and Allianz and others.
Morning, Mr. Russell. Just before you resume, the court's been discussing the question of the proposed third ground of appeal.
Yes.
And it seems to us to the most...
Sorry. Can I interrupt, my Lord? I have instructions to discontinue that application.
Oh, very well. Well, that answers that point then, doesn't it? I can't say I'm surprised in the light of Mr. Russell's submissions.
Well,
You don't need to say any more, Mr. Hill. You've indicated that you're not pursuing the point. I don't need to hear any more. Thank you very much. Yes, Mr. Russell.
I'm grateful. Lord, you should have on your desk an updated version of our propositions from yesterday.
Yeah.
Unfortunately, well, perhaps not unfortunately, what was a one-page document is now a four-page document. Yeah. What we've done, and I hope this is the task that
yes, that's very helpful.
Lord asked us to do, is we've put in references to the cases where we say illustrate the proposition. It's obviously a non-exhaustive list. One can go on forever with the cases, but those are some of the key ones for each proposition. What I intend to do this morning is take you through some of those authorities which we say either establish or illustrate the principles that apply, then deal with some of the cases that my learned friend relied on, and then at the end touch on our respondents' notice points.
Yeah, thank you very much. Right,
So the first case that I propose to take your lordships to is the Rossmore, which is at tab 2 in the bundle. It's a decision of the Court of Appeal in 1895. Court of Appeal made up of Lord Esher, Lord Justice Kay, and Lord Justice Smith. It was a case that was decided under the Harter Act, but it is cited in subsequent cases, and there is no suggestion that the principles which apply to unseaworthiness and due diligence.
It's the first case which deals with the issue of whether the duty is non-delegable.
Yes. Yeah. And it's cited in the later authorities. When we looked at the head note, we see that it's a porthole case. The owner of the vessel supplied proper equipment and appointed a competent ship's carpenter, but by the negligence of the carpenter, the ship was allowed to go to sea in an unseaworthy condition, by reason whereof a part of the cargo was damaged during the voyage. Held, affirming the judgment of Mr. Justice Lawrence, that to exempt the ship owner from liability, it was not sufficient merely to show that he had personally exercised due diligence to make the vessel seaworthy, but it must be shown that those persons whom he employed to act for him in this respect had exercised due diligence, and that therefore the negligence of the ship's carpenter prevented the exemption from applying, and the ship owner was liable. And the facts are set out at the foot of 408 to the top of 409. The ship's carpenter who had been employed failed sufficiently to screw down a porthole. If I could invite you then to look at the way in which the case was put in argument, because really, in some ways, it mirrors the way in which the arguments are put in this case. Yeah. If you look at 411, there is, just between the hole punches, a summary of the argument on behalf of the owners. Allowing the ship to sail with the porthole insufficiently closed was an error in navigation within the exceptions of the bill of lading. The contrary case was put on behalf of the cargo interests over the page at 412, just below the first hole punch. The exceptions relating to faults or errors in navigation or in the management of the vessel apply to the voyage and do not touch the question of the seaworthiness of the vessel at starting. So we've got two key points here. The first is the application of the, in that case, contractual exceptions to the duty of unseaworthiness, obligation of unseaworthiness, and secondly, the non-delegability point. And then the...
I suppose it might have been questioned whether closing a porthole was really part of navigation, but it seems to have been treated anyway as if it was.
We can
And a previous case apparently says that.
Yes, we can look at that. In fact, it was doubted whether it was navigation or management by Lord Justice Kay, but he held it was unnecessary to decide that point because we decided on other grounds. So there was some discussion as to whether that was the case or not.
What matters for your purposes is that whether or not it was navigation, whether we would regard it as navigation, is beside the point.
Yes.
The court proceeds on the basis that it was
It's
navigation.
on that basis. Yeah.
Yes.
The exception didn't apply.
Yes, exactly. So the relevant passage in the speech of Judgment of Lord Isher is at 413, and then over the page on 414.
Do you want us to read that to ourselves?
If your Lordships would, please. And there's a further passage further down that page between the hole punches. It starts towards the right hand side with the words, "It seems to me." It seems to me impossible to say that she was seaworthy at starting, so that she could perform an ordinary voyage without damage to the cargo. Her unseaworthiness was the fault of someone employed by the owner as his agent for the purpose of making the ship seaworthy before she started. That's the same as if the owner himself had been guilty of the negligence complained of. So it's the non-delegability point, but also the fact that the agent was employed for the purpose of making the ship seaworthy before she started. And then at the foot of 414 and over the page on 415 in the judgment of Lord Justice Kay, he deals with the temporal point. It says that the exceptions, contractual exemptions, don't apply. He agrees with the argument that they apply during the voyage, and contrasts that with the obligation to exercise due diligence to make the vessel seaworthy. He then goes on to raise the question: well, is this navigation or management at all? But concludes it's between the hole punches. It does not seem to me necessary to give any decided opinion on the point. And then, starting by the second hole punch, he goes on to what he calls the main question: whether the owners fulfilled the condition upon which they're entitled to exemption by the exercise of due diligence to make the vessel seaworthy. And over the page on 416.
I mean, he appears to have thought that it wasn't either, actually.
Yes.
There wasn't within the exception at all.
At all.
I suspect that in a modern context, the court would take a different view.
Yes.
If it arose, as it were, during the course of the voyage. Or,
yes. In my submission, it would now quite clearly be identified as management. Yes.
Yeah.
So the Goss-Millard decision is viewed as being the classic case on meaning of management. 416, he deals with the non-delegability point.
And it's the passage between the hole punch and 416. It seems to be plain on the face of the contract. What was the intent? Intended was that the owner should, if not with his own eyes, then with the eyes of a properly competent agent,
Yes.
ensure seaworthiness.
And then there is a passage to the same effect on 417 in the judgment of Lord Justice A.L. Smith. Starting just before the bottom hole punch, he deals with the non-delegability argument, and then in the final paragraph on that page, he deals with the temporal point and the exceptions point.
Yes.
The final sentence on that page. I may say, however, that I think the meaning of the section is that if the ship owner by himself or his agents uses due diligence to make the ship seaworthy when she starts, he shall not be liable for what happens afterwards when the ship is at sea and he has no more control over her.
Yeah.
And in relation to the various propositions, obviously we rely on this as being a one-off case, as so many of the cases are. It was a one-off instance of negligence on the part of the ship's carpenter failing to shut the porthole. I identified it in the document as illustrating that as well. So the next case in the next tab is the Kalima, which is a US case, but again it's cited, and it's dealing with the Harter Act, but again it's cited in the later English authorities and is viewed as being a correct statement of principle. In this case, the vessel capsized and sank in heavy weather following departure from San Francisco, but the weather conditions weren't in any sense exceptional, and although the vessel was quite tender, she should have been able to withstand the seas if the cargo had been properly stowed. It was held that the reason for the capsize was that she was unstable because of the combination of the inherent tenderness and the way in which the cargo had been stowed. The pagination is not entirely straightforward in this case. If you flick in through a few pages, you'll see that in the heading of the case there are numbers at the right-hand side. And although they don't go up sequentially, those are in fact the page numbers from an earlier version of the report. If I could invite you to go to page 21, looking at those numbers at the right-hand side of the heading.
Beginning other negative circumstances confirmed. Is that the one?
My lord, no. It's
Oh no, I've got. Sorry, I beg your pardon. Yes, I
so
see.
the first full paragraph starts my conclusion.
Yes.
My conclusion, therefore, on this branch of the case, from the direct and circumstantial evidence, is that the Kalima capsized in a heavy squall or brief storm, but little above an ordinary gale, because from her tender model and mode of loading combined, she lacked the usual and requisite stability or righting power, and in consequence of that fault she rolled deeply and recovered slowly. There is then a discussion of due diligence, which is using the same numbering at page 30, which I think is 2 pages further on in the bundle. And perhaps I could invite your lordships to read from the right-hand column, paragraph 3, to the first paragraph over the page.
Where in fact the Rossmore is cited.
Yes. And in the first full paragraph, starting on page 35, it says, a danger of the seas, which was one of the exceptions in that case, by a settled meaning, does not include a danger which would have been avoided by the use of due diligence in loading or management. And that part of the section would therefore not apply. So again, the exceptions don't apply where there's been a failure to exercise due diligence to make the vessel seaworthy. Then picking it up at the bottom of the left-hand column, it is further urged that the master's acts in stowing the ship, with reference to her stability and seaworthiness, have to do with the management of the ship, and are therefore within the third section. And some language is cited to that effect, the case of Worsted and Mills, but that case arose upon facts done at a port of call in the course of the voyage, and what was there said had reference to acts designedly done for the management of the ship in the course of the voyage. It is to management on the voyage that the third section of the Harter Act refers, as the context indicates, and not to acts like those in the present case, in preparation for the voyage, before it begins. So the distinction is between management, and we would say navigation and management during the voyage, which is an accepted cause, and navigation and management in preparation for the voyage, which is not an accepted cause. If acts or omissions in preparation for the voyage result in unseaworthiness, then it doesn't matter that they might be characterised as acts of navigation or management. They are not excused, notwithstanding that characterisation, if they are acts or omissions in preparation for the voyage. Acts or omissions can have more than one characterisation. They may be both acts of navigation or management and acts in preparation for the voyage. And one has to ask oneself, what is the relevant characterisation in a particular context? When one is looking at 3.1, the relevant characterisation is that they are acts in preparation for the voyage. Regardless of whether they are to be viewed as acts of navigation or acts of management, if they are in preparation for the voyage, then they go to due diligence and unseaworthiness under 3.1.
I suppose one could envisage a case where an act in preparation for the voyage which did not render the ship unseaworthy might be within the exception in 4.2a or one of the other exceptions.
Yes.
So I think the English cases might, the later cases under the Hague Rules, might not make the same temporal distinction. The distinction really that emerges from the Maxine footwear case as to it being a paramount duty under Article 3, Rule 1 is in effect that it's no use saying it's navigation and management of the ship if in fact the acts and omissions have led to the ship being unseaworthy.
Yes, the key proposition we say is that it is, whether it is done in preparation for the voyage or not. The point that your lordship makes is perhaps reflected in part of the judgment in the Apostolos case, where work was being done on the ship, hot work was being done, but the hot work was not being done to prepare the vessel for the voyage. It wasn't necessary to do that particular hot work to make the vessel seaworthy for the next voyage, and it was really on that basis that that is one of the bases on which the Court of Appeal held that there was no breach of 3.1. So often answering the temporal question will be sufficient, but in fact we would suggest the true test is whether the act is done in preparation for the voyage to make the vessel seaworthy for the voyage.
Yeah.
Because of course,
if it's in preparation of the voyage to make the vessel seaworthy,
yes.
then that goes without
Yes,
saying.
exactly. And of course we say that is precisely the circumstances of our case, because it was necessary to ensure that the written warning was on the chart to make the vessel ready and safe for the voyage out of Jamen.
And that dual test or double lock is reflected in the wording of Article 3.1, which is before the beginning of the voyage to make the ship seaworthy. So
Yes.
the task is both before the voyage and to make the ship seaworthy.
Exactly.
Then it kicks in.
Exactly. It all comes back to the wording of the article. What is the relevant task? It's to exercise due diligence to make the vessel seaworthy. When? Before and at the commencement of the voyage. Before and at the beginning of the voyage. If we could then look at McFadden itself. This is a decision of Mr. Justice, I don't know whether it's Channel or Chanel. Channel. This is it's a stopcock case, as one can see from the head note. And in this case, this is a pre-Hague Rules case. And at this stage, in relation to the temporal argument, the doctrine of stages still applied. So that the view was that the vessel had to be seaworthy to receive the cargo when the cargo was put on board, and then separately seaworthy when the voyage commenced. But there was a temporal gap between those 2 points in time, and if the relevant act or omission took place in that gap, or the vessel was unseaworthy in the temporal gap, it wouldn't lead to liability. So the judgment has to be seen in that context. We'll see that again. That's the argument that was run under the rules and rejected under the rules in the Maxine footwear case. But it was still a live doctrine at that stage. The relevant passage for our purposes is at page 706. Starting between the two hole punches, sentence beginning towards the right-hand side, whether a particular defect is sufficiently substantial to amount to a breach of the warranty, that's the warranty of seaworthiness, must in all cases be a question of fact. But it's a question of fact which must be determined by certain rules. And the rule applicable to the present case is, I think, correctly stated in a passage in Carver on carriage by sea, where it is said that a vessel must have that degree of fitness which an ordinary, careful and prudent owner would require his vessel to have at the commencement of the voyage, having regard to all the probable circumstances of it. To that extent, the ship owner, as we have seen, undertakes absolutely that she is fit, and ignorance is no excuse. Again, of course, the obligation now is one of due diligence rather than an absolute one. But in terms of the test of unseaworthiness, the test holds good. If the defect existed, the question to be put is, would a prudent owner have required that it should have been made good before sending his ship to sea had he known of it? If he would, the ship was not seaworthy within the meaning of the undertaking. And the points that we draw from that are, firstly, of course, that the question of whether the vessel is unseaworthy or not is principally a question of fact. And secondly, that to the extent that there are conceptual limits to what may constitute unseaworthiness, it is simply what we have been referring to as the McFadden test. That is the rule that is to be applied. And
Well, that's your point, that it doesn't have to relate to the attributes of the vessel.
yes, there's no need to gloss the rule. It's a question of
Whether you're right or wrong about that, the fact of the matter is that on the facts of this case,
yes,
the judge has found that there was unseaworthiness because there was a defect in the charts, and the defect in the chart was something that went to the attributes or
Yes.
affected the attributes of the vessel.
yes, absolutely,
And you'd say that's a finding of fact which is binding on
yes, exactly,
the appellants.
yes.
So in a sense, it's not. I'm not suggesting we necessarily will duck the point, but you don't need to go as far as you do. Is really, I think, what I'm saying.
No, indeed. I'll develop this submission when we look at the authorities that are relied on by the cargo owners in this case. The cases like the Apostolos and the Kapitan Sakharov and so forth are really they're cases on in the outer penumbra of unseaworthiness cases. They're difficult cases. They're, another way of putting it is they're the papery outer shell of the onion. Our case is very much at the sweet, rich centre of the onion. It's a paradigm case of unseaworthiness.
You'll have us all in tears.
That's very much touché. I hope not.
Okay, so that's McFadden. That's McFadden.
That's McFadden, yes.
You refer to it as the McFadden test. It's really the Carver test, isn't it? I mean, in later cases, it's I think it comes up later, isn't it? In one or two of the cases after Hague Rules were passed. The point about the prudent owner is attributed to Carver rather than.
Yes, and it appears in the Bradley case, and it's very often referred to as the Bradley case as well as Bradley test as well.
But it's all the same test.
It's all the same test. Yes, it all goes back to the passage in Carver.
Yeah.
So the next case is the Ciampa case, and as your lordship has just said, in this case, or in our case, I don't need to persuade your lordships that the attributes test is not part of the test. But this is a good illustration of a case where the vessel was held to be unseaworthy, yet it is difficult to analyse it in terms of attributes of the vessel herself. This was the case I mentioned yesterday, where the vessel had gone to Mombasa earlier in her rotation, had then gone to Naples, loaded a cargo of lemons at Naples, and then for discharge at Marseille. Because she had called at Mombasa, which was a plague port, it was inevitable that she would need to be fumigated before arrival at Marseille, and it was inevitable that the fumigation would damage the cargo of lemons. And you can see the relevant passage on page 780. I should have said this is a decision of Mr. Justice Rowlett. On 780, the key paragraph is just below the first hole punch. Sentence starting in the middle of the page. The defendants therefore received the lemons on board their ship for carriage, the ship being at the time free from sulphurous fumes, but circumstances existing which rendered inevitable that the ship and cargo would in the course of the voyage be subjected to them, that's to the sulphurous fumes. The ship was therefore, in my opinion, unfit to receive and carry the cargo. That is what is meant by unseaworthiness, quite apart from the fitness of the ship to traverse the ocean. So, as I say, it would be difficult to describe the fact that she had previously called at Mombasa as an attribute of the ship, but nonetheless held to be unseaworthy. And the case can be viewed, in my submission, as a straightforward application of what we're calling the McFadden test. Would a prudent master allow this ship to go to sea on this voyage, that is with this cargo, to the intended destination as she is? Or would he allow the ship to load the cargo for that voyage? The answer is no, because the cargo will inevitably be destroyed before it is capable of being discharged by reason.
And this is a case which is very difficult. This case is analysed in some detail by both Ms. Justice Hoghouse and the Court of Appeal in the Derby. And at least on one view, it's a case where the relevant terms, because it's unseaworthiness at Marseille that matters, isn't it?
No, it's unseaworthiness at Naples.
It's at Naples.
Yeah, Naples, yes.
But isn't it the fact that, sorry, I meant Naples, it's where the lemons are loaded.
Yes.
It's the fact that the ship was such that it was, no mind where it had been previously, but it was in a condition where it required fumigation.
But it required fumigation because it had been to Mombasa?
Yeah. But I mean, it's the requiring fumigation that might be said to be an attribute, I suppose. If you were looking for an attribute, that's what you might.
Yes, yes.
I think that's what Mr. Justice Hoghouse thought in the Derby.
Yes, I mean, you could view that as an attribute. It's rather, in my submission, rather strained.
Well, I see that. Yeah.
It's easier to view it as a straightforward application of the unglossed McFadden test. That a ship owner wouldn't allow this cargo to be loaded on this vessel because the vessel cannot safely carry that cargo to its intended discharge.
Is it so hard to see a ship's past trading pattern as part of its history and therefore attributes? If it's necessary to look for that?
It's very impressionistic.
Fair enough.
Yes, and as Mr. Coffer rightly points out, if that's right, if you see it as an attribute, it merely demonstrates how wide the test of an attribute is.
Yes.
So Russell, could you keep your voice up quite a bit because there's a lot of building work.
Of course,
and
yes.
mediation going
Yes.
on. Thank you.
It's not a common complaint that I talk too quietly. The next case I was going to take your lordships to is the Thordock, which is at tab 7. It might be worth just very briefly having a look at the Chellu case, which is at tab 6 before we do that. This is a case in which the vessel was held not to be unseaworthy. It was a charter party round trip to the Baltic, and it was argued that the vessel was unseaworthy or not fit for the voyage because she didn't have a Swedish certificate of measurement. Held that the owners were not liable. The ratio is that they weren't liable because that was not a document that was habitually obtained by owners or masters for vessels. And so I mention it because in some ways it's a very early case, but in some ways it fits into the orbit analysis of later cases, because one can view it as being a case where the court has held that the responsibility for obtaining the particular document was within the sphere of responsibility or the orbit of the charterers rather than the owner or master.
Well, that's at least part of the ratio of the Derby in due course in relation to the ITF issue, isn't it?
Yes.
That at the end of the day, it was a matter for the charterers.
Yes.
They chose to send the ship to ports where the ITF were active.
Yes. Yes. Yes, and also, of course, whether it's part of the ratio, also whether the terms on which crew are employed is an attribute of the ship or not.
Yeah.
Another way of analysing it is, again, just applying the McFadden test. Would a prudent ship owner prevent his vessel from going to sea because of the terms on which the crew are employed? Well, there's no reason not to. There's nothing that is imperiling either the ship or the cargo or the crew themselves. So we have the Paterson Steamships case, which is the vessel called the Thordock, which is at tab 7. This is a Privy Council case. The panel of the Judicial Committee was Lord Atkin, Lord Thankerton and Lord Roach. And this is a helpful case in terms of exercise of navigational skill and seamanship. The case involved the adjustment of the compass, and the vessel grounded because the compass adjuster who had been engaged by the owners had not properly adjusted the compass. In terms of our propositions, it's a one-off event, the failure by the adjuster to adjust the compass properly, and it's a failure to exercise due diligence in a one-off event, which requires the exercise of navigational skill. The swimming of a compass is often described as an art, not a science, certainly not a mechanical task. And whether you describe it as an act of navigation or not, it's plainly a nautical skill or a matter of good seamanship. Now, the reported decision of the Privy Council was in relation to a limitation claim, where the relevant test is obviously very different. It's actual fault or privity of the owners. There had been an earlier cargo claim which had been determined pursuant to the then in force Canadian Water Carriage Act, which contained a provision that was similar to what became the Hague Rules Article 3.1. You can see the relevant provision of the Act at page 37. The page numbers are either at the top right for odd pages or the very top left for even pages. One has page 37. In the left-hand column, just before the second hole punch, the relevant clause is set out. And in substance, it's materially same as 3.1. And there is a discussion of the cargo claim at page 40. invite your lordships to read the paragraph that starts as to the condition of the compass.
So the result was that they were liable under the cargo claim, but they were entitled to limit their liability.
Yes, exactly. It's the contrast
Canadian
between
Merchant Shipping Act.
it's the contrast between non-delegability under the Act in relation to the cargo claim.
Personal.
Exactly, and then personal fault or privity in relation to the Limitation Act. So again, it illustrates the non-delegability principle in relation to 3.1, or what became 3.1. Specifically, when one looks at the arguments that are run by owners in our case, it's non-delegability principle in a case where you have a one-off act of negligence, and that is an act that is very much in the exercise of a nautical skill or exercise of good seamanship.
Yeah.
Then we have Maxine Footwear at tab 8. It's another Canadian case in the Privy Council, and the panel made up of Viscount Kilmore, Lord Reid, Lord Tucker, Lord Somerville, and Lord Denning, and the advice is given by Lord Somerville. Time has moved on, and we have
argued cello, actually. He'd argued cello was Mr. David Somerville. QC, or Casey rather.
Yes. Time has moved on, so it's again it's under a later Canadian Water Carriage Act. This time, incorporating the Hague Rules themselves, and it was a case of a fire on board the vessel. The fire was caused by the negligent use of I think an oxyacetylene torch to thaw out frozen scuppers. So again, a one-off event, and we would say not a mechanical task. There's obviously a degree of skill required in the exercise of the task. It's an exercise in good seamanship. And there were three main arguments for the owners. There was the capacity or delegability issue. There was reliance on the fire exception in 4.2b. And then also there was a temporal argument based on the doctrine of stages approach. It was said that the hot work took place after the cargo had been put on the vessel, but before the vessel sailed. In fact, she never sailed because of the fire. And it was held that, applying the old common law approach, the vessel only had to be seaworthy when the cargo was put on board, and then when she sailed, with a temporal hiatus between those 2 points in time. And it's this case that laid that doctrine to rest as a matter of English law. The three arguments are dealt with at pages 602 to 603 in the report. And it's probably helpful to start with the reference to the dissenting judgment of Mr. Justice Cartwright in the Canadian Supreme Court. Cartwright J. dissenting at the top, towards the top of 602. And perhaps I could invite your lordships to read from there through to the end of the first paragraph on 603. very clear and powerful judgment in relation to both the non-delegability point and the application of the exceptions point. And then, after the paragraph that I've invited you to read, he deals with the doctrine of stages argument and concludes at the foot of 603. On that view, the obligation to exercise due diligence to make the ship seaworthy continued over the whole of the period from the beginning of loading until the ship sank. There was a failure to exercise due diligence during that period. As a result, the ship became unseaworthy, and this unseaworthiness caused the damage to and loss of the appellant's goods. So,
In the sense of the one way of looking at Mr. Hill's argument about if the master and crew are acting qua navigator as opposed to qua carrier, that somehow the exception can be relied upon, seems to me at least one way of looking at that is to say, well, it's an attempt to revive the same discredited doctrine. It's a point we touched on in argument yesterday.
yes.
And I think you're going to come on to the Captain Sakharov and to some extent
Happy Ranger.
Riverstone Meat as well.
Yes.
The point being there that they were dealing with the issue as to whether the ship owner could be liable for things that preceded any suggestion that he was actually responsible for the cargo.
Yes, exactly.
Once the ship owner is responsible for the cargo, then the Hague Rules will apply, and you don't, as it were, come in and out of them. And certainly in terms of the seaworthiness obligation, it continues right the way up until the voyage commences.
yes.
In
Yes.
this case, demonstrates that it's an overriding obligation.
Yes, I mean, my reference qua carrier, qua navigator argument emerges from the use of qua carrier in cases like the Captain Sakharov. But it's a wholly erroneous argument, because what's being contrasted is acts done by the carrier and acts done by other interests, such as the shipper or manufacturer of the goods. It's contrasting what the carrier does with acts that are done by persons entirely out with the carrier's orbit. So you have the Captain Sakharov, manufacturer and stuffer of the cargo, of the containers, all taking place before the goods come anywhere near the carrier's orbit.
Yeah.
Similarly, the shipbuilding cases, so the Anglis and the Happy Ranger, where the negligent act or omission takes place before the vessel comes within the carrier's orbit.
Yeah.
But
It's the point Lord Merriman makes in Riverstone Meat, isn't it?
yes, we go back to Lord's Venn diagram analysis. You've got a circle that encompasses the shipbuilder's orbit. You've got a circle that encompasses the shipper's orbit before the cargo is brought to the vessel at all. And then you have the carrier's orbit. Those three orbits, or those three sections of the Venn diagram, don't overlap at all. Once the cargo and the ship are within the carrier's orbit, then he is responsible for everything that goes to making the vessel seaworthy for a particular voyage. And to the extent that the task of preparing the vessel for the particular voyage is delegated to the master and the navigating officer, everything they do is within the carrier's orbit. All the acts that are performed by the master and second officer in preparation for the voyage to make the vessel seaworthy are within the carrier's orbit. They are all acts that are carried out by delegates of the carrier qua carrier. And to have sub-sections or smaller circles within the carrier's orbit, of the navigator's orbit to do the passage plan, the chief engineer's orbit to make sure the engine has the right lube oil in it. The carpenter's orbit to make sure that the porthole is properly closed, or the stopcock properly shut. The mate's orbit to ensure that the bow doors of the Herald of Free Enterprise are shut. That there may be separate little circles within the carrier's orbit, but everything that is done with the view of making the vessel seaworthy in preparation for the voyage is within the carrier's orbit.
Because they are in effect agents, as the previous case
Yes.
said, or delegates.
Yes. Yeah. And the qua carrier, qua navigator point simply falls when one applies the non-delegability principle.
Yeah. Thank you.
Yes, so the next case is the Moncaster Castle case.
Yeah.
And this, of course, is a House of Lords case rather than a Privy Council case. And therefore, although the principle of non-delegability had already been very well established by the cases that we've looked at, it's the Moncaster Castle that is often treated as being the leading case on non-delegability because it's a House of Lords authority. It's another repair case, and the House of Lords held that the owners were liable for the negligence of a fitter employed by ship repairers. And we've sidebarred a long passage from page 838 through to 844. But the key paragraphs are those at the foot of 842, firstly. Having cited most of the cases we've looked at, he says, it would be strange if the ship owner were liable for the negligence of an expert who is called in just because work is beyond the competence of the owner, was not liable for that of the independent contractor. It may indeed be asked whether the expert is not typically an independent contractor. So, in relation to the argument that in this case, the exercise of preparing the passage plan is one requiring the skill of a navigator, there's no distinction to be drawn between the tasks that are delegated by the owners to different individuals.
Or tasks which are outsourced to an independent compass adjuster.
Yes, exactly. Yes, exactly. It doesn't matter to whom the task is delegated or what the nature of the task is, provided it is in preparation for the voyage and making the vessel seaworthy, then regardless of the nature of the task or the status of the individual to whom it is delegated, the owners are responsible on a non-delegable basis. And a similar point is picked up from the middle of 843 onwards. Plea that the ship owner is not liable for the negligence of an independent contractor failing as a general proposition, as it was bound to fail in the light of the authorities that we've looked at, and that upon the facts of the present case, the respondents were not liable for the negligence of the fitter employed by the ship repair. It was then urged that it was a question of fact in each case, and that upon the facts of the present case, the respondents were not liable for the negligence of the fitter employed by the ship repairers. It was for this reason that I've stated the facts fully at the beginning of this opinion. Having done so, I must say at once that I find it impossible to distinguish between one independent contractor and another, or between one kind of repair and another. So that really is establishing the proposition that I just made, that there are no limits to the non-delegability principle, provided that it is a matter that goes to unseaworthiness.
Yeah.
So, any attempt to carve out the acts of the master or the navigating officer in preparing the passage plan must fail in the light of this authority. And to similar effect, we could perhaps look at a paragraph in the speech of Lord Radcliffe on page 864. He refers to the authorities and says, these sources seem to me, it's about 4 lines down, these sources seem to me to be wholly in favour of the appellant's claim. We have, to begin with, the common learning that the words in question were adopted by international convention in the Hague Rules at a time when they had been for many years familiar in the Harter Act of the United States. We know what content successive decisions of American courts had given those words. That the carrier was responsible to the cargo owner unless due diligence in the work had been shown by every person to whom any part of the necessary work had been entrusted, no matter whether he was the carrier's servant, agent, or independent contractor. Merely employing agents of good repute was not enough. So the non-delegability principle applies to any part of the necessary work, and it applies to every person to whom any part of the necessary work had been entrusted. It really couldn't be plainer than that. In this case, the task of preparing the passage plan and ensuring that the relevant warning is written on the chart is a task that is necessary to make the vessel safe for the voyage. The judge has found that as a fact. It's been entrusted to the navigating officer and the master. They fail to exercise due diligence. The judge has found that as a fact. The consequence is that the owners are liable. Now, if we pause there, we say that by this point, all the relevant core principles, certainly those that are necessary to determine this case, have been established. And the later cases are either simply applications of those principles to different factual situations, or are cases at the outer penumbra, as I said, of 3.1, the difficult cases, which are the cases that my learned friend has relied on. Our case, we say, falls very firmly into the first of those 2 categories, as the judge himself thought it did. It is a simple application of the principles that have been very well established to the facts of the case. As I say, the judge's findings of fact were that the warning had to be on the chart, inconceivable that any prudent owner would allow the vessel to go to sea without the warning on the chart, and the absence of the warning caused the casualty. So he has applied the principles that are established on the highest authority to the facts as he found them. What I propose to do is to show you just 2 more cases that illustrate the application of those principles in seamanship cases. Then look at the Derby, specifically because of what is said in relation to charts in the Derby, and then deal with my learned friend's authorities. So the first of the 2 cases is the EV number 2, which is at tab 14 of the bundle. And this is helpful because it shows how a one-off failure by the master in relation to an exercise of navigational skill and judgment can render a ship unseaworthy. This is the case where the vessel ran out of fuel en route from Portland to Yokohama because the master had miscalculated the amount of fuel that he required. So that was one of the two alternative possibilities as to why she ran out of fuel. There was an alternative possibility that the fuel was bad, which of course would have itself rendered the vessel unseaworthy. And the reason for the vessel not having enough fuel was because the master, when calculating the distance to be run on the voyage, had used a great circle route rather than a rumline route when the vessel was going to be following a rumline route. So he had calculated the distance using the shorter great circle route when that wasn't the route that he was going to take, and he'd also failed to take into account an adverse current. So you can see that at page 353, right-hand column at the bottom. The master, of course, made a report. He started off with his calculations and he got them wrong. At the top,
Well-known counsel in this case.
Yes. By this stage, a very rare appearance by Mr. Worthy, although he just seemed to have been in a lot of the earlier cases.
yeah, it's a fairly strong.
Essentially, the Court of Appeal upheld Justice Donaldson's findings of fact.
Yes. Yeah. And then, if we move on to 353. I'm sorry that we've looked at that. 354. The foot of the left-hand column. He says the judge did not accept this. That was a submission made that the judge's calculation, that the master's calculation was right. Judge did not accept this. He did not accept that there was enough fuel on board for the voyage so as to make her seaworthy at the start. I must say I can see no reason why the judge, after hearing all the evidence and going into it, should not have come to that conclusion. There was not enough fuel on the vessel to take her across the North Pacific at that time. She was unseaworthy from the start. And then if one goes to 355, the Lord Denning cites the judge's judgment and approves of it. He says, this is how the judge put it: "It follows in my judgment the vessel was unseaworthy at the beginning of the voyage, either because they had insufficient bunkers, or because they were of the wrong quality, or for both reasons. This unseaworthiness was the cause of the casualty. Furthermore, each form of unseaworthiness could and would have been avoided if the owners had exercised due diligence to make the vessel seaworthy. Contribution in general average is therefore irrecoverable from the defendant, and the claim fails." Now, he says that the owners, if the owners had exercised due diligence, that obviously would have been the owners exercising due diligence through the master, who was the one actually performing the calculations.
Or indeed through the bunker suppliers, if it was off-spec.
Yes.
Yeah.
Owners is used as a shorthand there because there's simply no argument. There could be no argument about the non-delegability principle. But what we have here is a negligent act of the master, very much the navigational sphere, if I can put it that way, calculating the distance that the vessel was to run and working out what the currents were going to be on the voyage. And so it's certainly inconsistent with any argument that navigation is in some way different.
It doesn't seem, does it, even to have been argued that because it was an error in navigation, that made all the difference.
No. There's no suggestion.
No, we haven't got the first instance judgment. We don't know whether it was argued before the judge. It doesn't look like it, does it?
No, I confess I haven't gone back to the.
As Lord Justice Lawton says, the litigation is a forensic monument to human persistence in making claims and resisting them. So one can't but imagine that if there had been a point, it would have been taken, especially given the eminence of the council arguing the case.
Yes, yes.
I mean, in a sense,
Well,
it's a sort of hybrid, isn't it, really? You could say it was an act of management, and it's all to do with how much bunkers do I need. In another sense, it's to do with navigation as well, because the reason for the miscalculation is to do with the master's navigational skills, which he got wrong.
There's certainly an element of navigation involved, because you've got to get your chart out to work out how far you've got to go.
And certainly in terms of the currency likely to encounter, you're absolutely right.
Yes.
Okay.
There's no indication that it was argued. In my submission, because it is unarguable. Once you have worked your way through the authorities that we have worked our way through, and particularly the speeches of Lord Sims and Lord Radcliffe in the Moncaster Castle, there's no scope for saying that some tasks are to be carved out if they go to the preparation of the vessel for the voyage. And coming back to our case, well, in that case, working out how much fuel you need is plainly an act in preparation for the voyage. Just as in our case, ensuring that the relevant warning is on the chart is a necessary task for the preparation of the voyage. If you look at the facts of the EV, it's again possible to posit a counterfactual scenario where the same act of negligence by the master would not have resulted in liability if it had occurred after the commencement of the voyage. Let us say that during the currency of the voyage, the chief engineer had made a mistake and pumped water into one of the bunker tanks so that the fuel in that tank was no longer usable, and the master had to calculate whether he had now had enough fuel remaining on board to make to the discharge port, or whether he was required to put into an intermediate port to rebunker. And let's say he got the calculation wrong, and the vessel ran out of fuel before reaching the discharge port. You would have exactly the same error by the master, failure to calculate the distance to be run, let us say, accurately, which results in the same outcome. The vessel fails to make the discharge port. But you have a different result, because it is no longer an act in preparation for the voyage, because it takes place during the currency of the voyage. And so, again, there's no magic or surprise in the fact that the structure of the rules means you may have different outcomes depending on when the relevant act or omission takes place. And so, it does not assist our friend to say, well, the judge's approach in this case may lead to capricious results. It's just hardwired into the structure of the rules. It's part of the trade-off.
Indeed, that illustrates the trade-off of the deal that was done and referred to in the cases you cited yesterday.
Yes.
As to where the bright line should be. Once the vessel sets off, then it's a different ball game.
Yes.
Yeah.
And then the friso, which is over the page at tab 15. This is another seamanship, a navigational skill, seamanship case, if you like, but perhaps more obviously in the management of the vessel than navigation in a purer sense. Again, of course, there's no differentiation in the rules between navigation and management. Both of those exceptions appearing in the same place in Rule 2. This is a case in which, in heavy, but again unexceptional weather, the vessel developed a heavy list and had to be abandoned, though in fact she was later recovered. Cargo had to be jettisoned to correct the list. The primary claim seems to have been under 3.2, and the owners failed to make out a perils of the sea defence. And you can see that from the foot of 474. Sidebarred passage. Then at the foot of the left-hand column in 474, the judge says, in case I am wrong in holding that a prima facie case of damage by perils of the sea has not been made out, we don't need to revisit what is or is not meant by a prima facie case of the exception being made out. I must consider the question, well, the plaintiffs have proved that the defendants failed before and at the beginning of the voyage to exercise due diligence to make the vessel seaworthy. And he holds that the vessel lacked stability because before the commencement of the voyage, the master had failed to press up the double bottom tanks, which were slack. And it was the slackness in the double bottom tanks which caused the list. And we can see that at page 475. And the discussion is from the left-hand hole punch, sorry, the left-hand column, but the second hole punch through to the right-hand column. And again, I say that this is an illustration of the principles that have already been established. It is a case of a one-off failure by the master to press up the slack bottom tanks. It's a failure, certainly in relation to the management of the vessel at the very least, and it's an exercise of seamanship, but in no sense is it carved out from the 3.1 obligation. I should say, actually, I say it's a one-off event. In fact, on the next voyage, it appears that the master failed to press up the bottom tanks again, notwithstanding the casualty that just occurred. And the judge relied on that second failure as evidence that, as a matter of fact, he had failed to press up the bottom tanks on the first occasion.
But at the time when the unseaworthiness occurred, it was a one-off.
Yes, the case was not analysed on the basis that the vessel was unseaworthy because the master habitually did that. The case was analysed on the basis of a one-off failure to press up the bottom tanks, rendering the vessel unseaworthy. Mm-hmm. So that covers those two cases. Then we have the Derby, which is at 19. I wasn't proposing to look at the actual decision in the Derby in detail. I wanted to take your lordships to the observations that are made in relation to charts, and those are firstly at 331. In the left-hand column, bottom paragraph, the second respect in which the scope of the words in line 22 has been held to go beyond the physical state of the vessel is that they've been held to cover the requirement that the vessel must carry certain kinds of documents which bear upon her seaworthiness or fitness to perform the service for which the charter provides. Navigational charts, which are necessary for the voyages upon which the vessel may be ordered from time to time, are an obvious illustration. And then he goes on to discuss certificates and so forth. There is a further passage which is of some relevance, and that is at page 332. At the very foot of the right-hand column on 332. And this is in the context of the scope of appeals from arbitrators' awards in relation to seaworthiness. He says, having referred to the NEMA, he says, I agree with Mr. Gazeman that issues as to a vessel's seaworthiness may involve questions of fact and degree on which the decisions of arbitrators could not properly be regarded as open to review. An obvious illustration, given the requirement that a vessel is unseaworthy unless she is equipped with all the charts which may reasonably be necessary for a particular voyage, is that it would no doubt be a question of fact whether the charts carried on board in a particular case were sufficient to comply with this obligation, or whether additional or larger scale charts should have been available. Now, we rely on that for two purposes. First, the fact that it is taken as self-evident that having the right charts on board goes to seaworthiness. Equally, we would say having the right charts properly updated, containing the relevant information that they need to contain, is self-evidently a matter which goes to seaworthiness. But also, of course, that it is a question of fact and degree, and the judge has made his findings of fact in relation to what was required to be on the charts in this case.
Indeed, you say the judge carried out a detailed fact-finding analysis and series of value judgments and came to the conclusion that he did.
Yes, yes.
Because it's rarely black and white.
So those are the authorities that I wanted to take you to, if you like, in relation to my positive case.
Yeah.
What I was going to do now is pick up on some of the authorities that are referred to in Manera Friend's roadmap, and then some of the other authorities that have been referred to in the skeleton argument. Hopefully I can deal with these quite quickly, because I think a lot of the ground has been covered yesterday in debate with your lordships. The first case is the Hill Harmony, which is at tab 25. So that's the very back of the first volume. And unless your lordships wish me to do so, I won't take you through the passages again. I mean, what we say in relation to the Hill Harmony is that it's not a case that's dealing with unseaworthiness at all. The issue in the Hill Harmony was what matters were within the sphere of employment, which was for the charterers to determine, and what matters were within the sphere of safe navigation, which were for the owner and the master to determine. And whether an order is an order as to the employment of the vessel for the purposes of Clause 8 of the NYPE form assists you not one jot in deciding what the relevant test for unseaworthiness is. And this comes back to a point that I made earlier. It may well be possible to characterise an act that takes place before the commencement of the voyage as having a navigational or management flavour to it. But that's not the relevant characterisation for the purposes of Article 3, Rule 1, because navigation and management are not exceptions to 3.1. The relevant characterisation is whether it is an act in preparation for the voyage, whether it is an act that is necessary to make the vessel safe to prosecute the contemplated voyage. And once it has that character, it matters not what other character it might have, because it is an act which is required to be exercised with due diligence.
Again, if you used a Venn diagram, you would simply carve out those into the relevant circles. So criteria has to be an act for the preparation of the voyage, whether or not it's navigational quasi-management or not?
Yes, in terms of the Venn diagrams, you'll have one circle, which is the acts that are necessary to prepare the vessel for the voyage. All of those acts go to 3.1 liability. You will then have another circle, which is acts of navigation and management by the master and crew. And that will or may, depending on the particular facts of the case, overlap to a certain extent with the acts for the preparation for the voyage. Because some acts will be of management will be required for the preparation of for the voyage. And other acts of management will take place after the voyage has commenced. Where the acts of navigation and management are not within the sphere of acts that is required to prepare the voyage, to prepare the vessel for the voyage, then the 4.2a exceptions are likely to apply. Where the acts of navigation or management fall within the circle in the Venn diagram that is acts necessary to make the vessel seaworthy for the voyage, they do not attract the application of the exception and do lead to liability on the part of the owner if the result is that the vessel is unseaworthy and there has been a failure to exercise due diligence.
I suppose if Lord Hobhouse had intended to say something about whether an act of navigation before the commencement of the voyage was something which went to seaworthiness, he might have wanted also to say something about the EVFI in which he'd been successful counsel.
Yes, I don't think that the word seamanship or seaworthiness appears at all.
Well, seamanship does, because he refers to Lord
Yes,
Sumner's
I'm sorry,
speech, but,
seaworthiness, yes.
seaworthiness is not mentioned once.
Yes.
It's just not about unseaworthiness at all. And the point of the case was that the master had failed to comply with the orders to proceed by the quickest route, because he didn't like going by that route because he'd had a previous bad experience in bad weather. And
Yes.
the point was made by the arbitrators and upheld by the House of Lords was that the two voyages in question were voyages which were in the summer and no bad weather was expected. So there was no justification for him refusing to obey the orders. And the point that Lord Hobhouse makes at 658 at sea, that obviously if the orders had been such that the vessel would have exposed the vessel to a risk which the owners hadn't agreed to bear because it would have been unsafe in some way, the master would have been entitled to refuse to comply with the order.
Yes.
But it just wasn't that case at all.
Yeah. It's a case about this.
Absolutely nothing to do with unseaworthiness whatsoever. And the point that Mr. Hill focused on yesterday about whether or not about the timing of acts of navigation is, as I read the judgment anyway, is simply Lord Hobhouse dealing with the fact that he thought that the decision, I think it's Mr. Justice Balehash, isn't it, in Lord and Newsom, that the result was right, but the reasoning was wrong, and so he deals with that point. But it's really en passant, isn't it? It's not really part of the ratio of his judgment.
No, I mean, the decisions, as the case works its way up the judicial ladder from the arbitrators to the judge to the Court of Appeal to the House of Lords, there are different views as to whether the decision as to route was navigational or going to employment. But none of that is of any relevance to the unseaworthiness question. It's all to do with the right of the master and owners not to follow orders. What is the scope of the orders that the charterers are entitled to give? Are charterers entitled to give orders as to route between two ports, or are they merely entitled to say go to port X? And you've got debate as well about the normal route between the ports in question. It's just not an unseaworthiness case.
Well, it's also a case about it's the two aspects of Clause 8, isn't it? It's the obligation to proceed with the utmost
Dispatch. Yes, exactly.
and the obligation to comply with orders of the charterers as regards the employment of a vessel.
Yes.
And as I read the judgment at 657 to 8, what he's really saying is, well, wide definitions of navigation which the owners relied upon don't help, because you can't try and subsume everything into navigation when actually what this is really about is failure to proceed with utmost dispatch.
Yeah.
So,
I mean, to the extent that it says that there can be acts of navigation before commencement, it doesn't go anywhere anyway for the reasons that we've analysed.
yep.
Then the aquacharm. I take the aquacharm next because it's actually another orders case. If one goes to tab 16 first of all, which is the first instance judgment, you can see that the relevant order that was given is at the foot of page 240, left-hand column.
So 240.
240. So we're in tab 16, page 240. Bottom of the left-hand column, the umpire found that the vessel was ordered by the charterers to load up to the draft permitted by the Panama Canal. So it's a time charter case, and the time charterers order the master to load cargo that will permit her to go through the Panama Canal. And the master gets his calculations wrong and loads too much. So when we go to the Court of Appeal decision, which is at tab 17, and Lord Denning says, for example, at page 122, at F, the master's fault, seeing that the cause of all the trouble was the master's fault in overloading the vessel. The point is that the master's fault in overloading the vessel was in putting in more cargo than charterers had instructed him to put in. But his fault is limited in that respect. He hadn't overloaded the vessel in the sense of putting the vessel in any danger or peril. The consequence of putting in too much cargo was merely that the vessel was required to lighten to transit the Panama Canal. And if you simply apply the McFadden test to this case, as my Lord Justice Mayles did yesterday, you can see it as a straightforward application of the test. If the prudent owner is asked, is there any reason for the vessel to go to sea in the state that she is in, with more cargo on board than permit her to go through the Panama Canal? The answer is no. There's no reason not to permit her to go to sea, because she's not in peril, she's perfectly safe, she can carry the cargo safely. That some will have to be offloaded to enable her to have sufficiently low draft to transit the canal.
Is it inherent in the McFadden test that the prudent owner's answer to the question is to be given by reference to safety and similar considerations as distinct from purely economic ones?
Well, if one looks at some of the documentary cases, the early documentary cases, it would suggest that it is not so limited. Because, for example, failure to have a document which then requires the vessel to be quarantined and leads to a delay can be seen as being a commercial matter rather than purely a
Yes.
Levy and Costerton, yeah.
Yes,
Yes, if it's not a perishable cargo, I suppose it is
Yes.
only money, isn't it?
Yes. Those early cases would suggest that it is not so limited. But again, that's the sort of question that explores the outer edges of the concept of
Well,
unseaworthy.
you would say it doesn't matter in this case.
It doesn't matter.
Clearly, this did
Exactly,
affect
yes.
the safety of
Yes.
the vessel.
Exactly, yes. I mean, that, in a sense, that's what I keep coming back to when faced with difficult questions as to what the outer edge are.
Well, I agree. You've got that escape route
Yes.
on the facts of this case.
It's-
I was just exploring your second proposition about no conceptual limits.
Yes. Yes. Well, we would say no conceptual limits.
The Derby would suggest, wouldn't it? Lord Justice Carr's judgment in the Derby does suggest that the certificates that are required might go beyond safety, I suppose.
Yes.
Based on one view. I don't think where it was now.
Well, the way in which I would put it in response to your Lordship's question is that it is a question of fact to be answered on the facts of each
Yeah,
case.
it's a passage at 331 at the right-hand column where it says, for present purposes, however, we are concerned with certificates bearing upon the seaworthiness of the vessel. The nature of such certificates may vary according to the requirements of the law of the vessel's flag or the laws or regulations in force in the countries to which the vessel may be ordered, or which may lawfully be required by the authorities exercising administrative or other functions in the ports of call. And then you've got certificates related to physical condition.
Yes.
So that, I suppose those might be said to be wider than merely looking at issues of safety.
Yes. I mean, as I say, the way in which we would put it is that there are no conceptual limits. It's a question of fact to be addressed in each case. And in answering the McFadden question, you have to look what the consequence, the particular consequences are going to be. But one shouldn't seek in advance to delineate categories of case that will never satisfy the test. One applies the test as it stands, and it's a factual question to be answered on the facts of the case.
Right, so that's the
Even within the broad facts of the aquacharm, you might get different results on the facts of a particular case if you drill down into the detail. Let's say, for the sake of the argument, that the lightning process is simple and straightforward because lots of lighters are available at the Panama Canal to carry out that task. Contrast that with a situation where it is notorious that the operators of the Panama lighters pilfer the cargo. You might get a different result in that case because the prudent owner would say, well, I'm not going to let my vessel go to sea in circumstances where she's going to have to lighten, because that will lead to a probable cargo loss because the lighter operators will pilfer the cargo. So I come back to my submission that there are no conceptual limits, but it is all fact specific.
Thank you.
So that's that. The next one is the Apostolos, which is at tab 48, which is at the back of the second volume. And I say up front, this is not a particularly easy case to understand or reconcile with other authorities in particular.
Glad you said that, Mr. Russell.
Sorry?
I'm glad you said that. I was puzzled by it when I read it.
Yes, it's not an easy case. I mean, one started off with the curiosity that before the trial judge, you had two competing causes of the fire in play. One, the hot works that were being carried out on deck, and secondly, a discarded cigarette by, I think it's Steve Dawes. a discarded cigarette from someone, and the judge found in favour of the hot works operation as being the factual cause of the fire, and that was overturned by the Court of Appeal, which is somewhat surprising in itself. Because the Court of Appeal found that the factual cause of the fire was a cigarette, and there could be no basis of liability on the owners in that case, because the dropping of the cigarette certainly wasn't a matter going to preparation of the vessel, making her seaworthy, and was caught by the fire exception because of there's no fault of privity on the owners for the purposes of 4.2b. What we've got to remember as a starting point is that all the discussion of the law in relation to the welding work is obiter. It's all in the context of the judge's finding that the cause of the fire was welding, which is not the basis on which the Court of Appeal decided the case. And Lord Justice Leggett addresses the point at page 245. He says in the left-hand column, the welding was not done directly above an open or partly open hold, and it may have occupied no more than a short time. The judge's conclusion that the carrier was carrying out welding work above the hold, which resulted in sparks raining into it, was therefore an ill-judged hyperbole. Nothing about the state of the ship rendered her unseaworthy. The owners were not in breach of 3.1, merely because welding exposed the cargo to an ephemeral risk of ignition. The holes themselves were not intrinsically unsafe. In Maxine, the House of Lords found it unnecessary to decide whether the vessel was on fire before the cargo was loaded. It was fire in the fabric of the vessel, namely the cork lining of the hold, which rendered her unseaworthy. Here the ship only became so on account of the fire in the cargo. It cannot even be said that the welding work was taking place in order to render the ship seaworthy. The fire might as well have been caused by a discarded cigarette, which, as the judge accepted, could not be a breach of Article 3, Rule 1. So, as I interpret that paragraph, what he is saying is that the negligent work, the hot work, if it had been the cause of the fire, was not work that was being done to make the vessel seaworthy. It was not work that was being done to prepare the vessel for the voyage. And therefore was not work to which the non-delegable duty under 3.1 attached. That is of no assistance to ship owners in our case, because the relevant work, the putting of the warning on the chart and the preparing of the passage plan, were tasks that were being done to prepare the vessel for the voyage. And then the discussion in Lord Justice Phillips' judgment is at page 257. Starting the left-hand column under the heading Rule 3.1, Article 3, Rule 1, he says the judge was urged to find that the cargo was damaged by unseaworthiness on two alternative bases. First, it was argued that, once the cargo caught fire, the fact of the burning cargo rendered holds number 4 and 5 unfit for the preservation of the cargo in those holds, and thus unseaworthy. The judge rejected that contention, and I think that he was right to do so. For a ship to be unseaworthy, or more strictly uncargo-worthy, there must be some attribute of the ship itself which threatens the safety of the cargo. If a hold is dirty, that's properly considered as an attribute of the ship, but the fact that a hold contains cargo which threatens damage to other cargo is not an attribute of the ship. And then he goes on to discuss the Thorso, which is the Gorgonzola cheese and chocolates case.
I wonder whether that was consistent with the Captain's Sakharov.
It's not. I mean, the Captain Sakharov comes later in time. It's a later case. That's why I say this statement in the judgment of Lord Justice Phillips is, in my submission, irreconcilable with the ratio of the Captain Sakharov, which was that the dangerous cargo on board, both lots of dangerous cargo, both the isopentane below deck and the undeclared dangerous cargo above deck, rendered the vessel unseaworthy.
Yeah.
The Captain Sakharov wasn't decided on seaworthiness grounds, it was decided on due diligence grounds.
Yeah, quite.
So this obviously is one of the passages where attributes of the ship comes in, and I say very dangerous to make too much out of that in circumstances where it appears in a passage that is obiter and a passage which is inconsistent and, in my submission, irreconcilable with the subsequent ratio of the Captain Sakharov. And then there's the second way in which the case was advanced is dealt with the bottom half of the right-hand column, and that really it's the same analysis as Lord Justice Leggett's analysis. In other words, the work that was the vessel wasn't seaworthy. The vessel was seaworthy, but she was having work done on her, not for the purpose of making her seaworthy, and that does not fall within the scope of 3.1. So in summary, it's all obiter. The main analysis, the consistent analysis in the two speeches, is that it's work that is not being done to make the vessel seaworthy, and therefore not within the scope of 3.1. That doesn't assist the owners. The only crumb of comfort that the owners might seek to draw from it is the reference to attributes in the speech of Lord Justice Phillips, but as I say, it's obiter and it's not consistent with Captain Sakharov.
But in fact, the difficulty for the appellants here is that in dealing with this case, the judge found that the defect in the chart was an attribute of the ship, so it doesn't actually, it's paragraph 85.
85, and that's,
deals with the apostasis.
and that's a finding of fact. In my submission, that must be a finding of fact that it's an attribute of the ship. So it's all supremely irrelevant. The next two cases.
Is it really a finding of fact? I mean, if one judge says that having an up-to-date chart is an attribute of the ship, and another judge in a different case says that it isn't, do both appeals get dismissed because they are findings of fact?
Well, I'm just looking at what the judge said in paragraph.
I mean, surely whether in the first place it needs to be an attribute of the ship is a question of law, but then
Yes.
and then you've got to define, which is also a question of law, what an attribute means, whether you give it a wide or a narrow meaning,
Yes, yes,
etc.
I see that. I see that.
But once you've done that and you've got a test, there must be an answer one way or the other.
Well, I can see that if a defect, as a matter of law, is required to be an attribute of the ship, then there may be a prior question of law as to what the proper interpretation of the word attribute means. Again, whatever it means, in my submission on the fact of this case, which is the important thing.
Well, I agree, we may not need to go there, but I'm just
No,
questioning whether
Yes,
you can, as it were, simply get home by saying, well, it's finding a fact.
I take your lordship's point.
I'm not sure he really is analysing it on the basis it's a finding of fact, pure and simple. I think what he's really saying, as I read paragraph 85, is it's well established
That it is,
that
yes.
defects in charts
Yes.
are an attribute of the ship.
And again, that's the important point for the purposes of the disposal of this appeal.
And that's a reference back to, well, obviously, amongst other cases, to the Derby.
To the Derby, it's in my submission beyond question, beyond doubt, that having a proper up-to-date chart with all the information that's required to be on it is an attribute of the ship, if that's a necessary part of the test.
Well, as he says, attribute or intrinsic to the vessel.
Yes. Yes, I mean it's however way you analyse it, making again I come back to the simple proposition, making sure that the necessary warning was on the chart was a task in preparation for the voyage. It was a necessary step in making this vessel safe for this voyage. The result was that the key navigational tool, the chart, which must be seen in my submission as being an attribute of the ship or intrinsic to the ship, was defective because it did not have the warning written on it. Lord, the next two cases are the Captain Sakharov and the Happy Ranger. Unless your lordships wish me to go to those, I've said what I want to say about those. That they're orbit cases and they don't assist. I'm grateful. The Teare, which is tag 27. Ultimately, as I understand Malone Friend's case in relation to the Teare, he relies on it for an argument that wasn't run, and he says that because the argument wasn't run by Mr. Brenton, that must mean that it's a bad argument and that the judge was wrong to find in the way in which he did. Just analysing the Teare briefly, the initial pleading, which is at 540 left-hand column, included the plea at sea that the vessel was unseaworthy because there was no proper passage plan for the part of the voyage during which the grounding took place. So that pleading is obviously entirely consistent with my case that a defective passage plan can render the vessel unseaworthy.
So you would give the credit to Mr. Thomas.
Well, that plea is
Don't worry,
that plea is
Don't worry.
in my case. When the judge discusses the law, he says at paragraph 78, there was, unsurprisingly, no issue as to the law.
Sorry, paragraph.
Paragraph 78, it's page 546. So, on one view, it wasn't in dispute that a proper passage plan could render the vessel unseaworthy. in the sense that when the judge has a section headed the law, he doesn't record any argument that the plea at sea was defective as a matter of law because passage plans can't render the vessel unseaworthy. Now, there were two passage plans. Passage plan of the ship that was prepared before the voyage effectively ran out when you got to the bit of the voyage where the pilots were going to come on board for the difficult passage through the Patagonian channels. Which I think I'm right in saying the vessel didn't have the relevant charts on board either. The pilots brought their own charts. So the ship's passage plan didn't say there be dragons, it said there be pilots, and left it at that. But any defects in that passage plan were not going to be causative because the relevant passage plan for that part of the voyage was the pilot's passage plan that they brought on board. And the judge found as a fact that the pilot's passage plan was not defective. Paragraph 99 on page 549. In any event, I am not persuaded that the pilot's passage plan would have been condemned as deficient by any competent mariner as a consequence of the absence of those three annotations. So again, anything that the judge says about the consequences of the passage plan having been defective is obiter.
Well, everything from 97 onwards, as I read it, is to do with the pilot's passage plan.
Yes.
Because that's how he starts it, isn't it?
Yes.
The starting point is according to consider the quality of the passage plan contained on the pilot's large-scale chart.
Yes, because the absence of detailed planning for this part of the voyage in the ship's plan couldn't be causative because they were navigating by reference to the pilot's plan.
Yeah, because it was the pilot's plans that they were following.
Yes, exactly. And so he finds that the pilot's plan is not deficient. So anything that he then discusses in terms of if it were deficient is obiter. And the passage the paragraph that my friend relies on is 100. So this is obiter. Let me assume in the claimant's favour that the passage plan, that's the pilot's passage plan, was defective in one or more of the respects suggested. It was not in the event contended that this flowed from any failure of the defendants to provide a proper system in the sense that the guidance and instructions furnished by the owners were in any sense appropriate. The point that's made is, well, that suggests that cargo owners' argument was based on systems rather than the more simple argument that the vessel was unseaworthy simply because of the defective plan. So it might be said that the cargo owners don't seem to have followed through in argument on the case that they had pleaded in C. But that's as high as it can be put. Bear in mind that in relation to the continuing obligation of unseaworthiness in that case, it wasn't a 3-1 obligation simpliciter. It was based on charter party clauses. The two clauses that might have been incorporated but were broadly to the same effect can be found at 537, clause 3.1 on 537. Continuing obligation to maintain and restore the conditions stipulated in classes 1 to 2A. And the alternative clause is set out at paragraph 12 over the page. It's clause 2 of the BP void form. Query whether the non-delegability principle that applies to 3.1 would apply in the same way to those clauses or not. I haven't fully researched that point because it's so far on the periphery of this case. But really what my friend's submission in the Teare comes down to is he relies on the Teare because Mr. Brenton in that case did not take a point in a case which turned on different facts and different contractual terms, which I now take. The judge analysed the case properly in my submission.
Well, in any event, this is a case where the judge found, first of all, that the pilot passage plan wasn't defective, and secondly, that the criticisms levelled at the master in relation to his passage plan were unwarranted.
Yeah.
And that I take it is the passage from, I think, 105 onwards, where he deals with the master's evidence about why the vessel's passage plan for this particular part of the passage was so exiguous, and effectively says, well, it's perfectly
Yes.
understandable why the master did what he did.
And therefore not evidence.
Those are the criticisms that he's referred to in paragraph 59 that he's dealing with at that point. So it all goes off on the fact.
As so many of these cases do.
As the judge said in his judgment, one doesn't really get much assistance.
Exactly. No, the fact that, as I say, the fact that a particular point may not have been argued in a different case on different facts and different contractual clauses 20 years ago is really not of a lot of assistance to this court today.
And it may have been a tactical decision by Mr. Brenton to go for competence or some other angle.
Then the Yalava here, which is the American case that wasn't referred to in any of the skeletons but was in the supplemental bundle, again, anything that was said in that case is obiter, because the finding was on causation. If you, I don't intend to take your lordships to it in the light of the time.
No.
If your lordships recall, it referred to another case which looked as though it might have had something relevant in it, a case called Avondale.
Yes.
We've looked at the Avondale, and it is a case of negligence simpliciter in respect of the failure of the master to liaise properly with the pilot. It's not a non-seaworthiness case at all. We've got copies available if your lordships would like to see them. I don't certainly propose to take your lordships through the Avondale case.
No.
And then there is the Gili High, which is the Noel summary judgment case. And again, I don't intend to take your lordships to that. I say forensically that it might be significant that is one of only 7 cases that my learned friend refers to in his roadmap, and it's not a case that provides any assistance to the court whatsoever. Not in the roadmap, but in the skeleton arguments, there's reference to a number of other cases. I just flag up the cases such as the England and the Marion that are relied on are limitation cases, and therefore have obviously a very different test. And so one needs to be a little bit careful when looking at some of the authorities that are cited to work out precisely what the legal framework was. And then, perhaps very briefly, just to touch on the Tasman Pioneer, which is the New Zealand case. It's in the second authorities bundle. Tab 30. And paragraph 8 was the paragraph that was relied on. And a couple of observations. One needs to be careful with the labels of commercial fault and nautical fault. The labels certainly are consonant with our friend's argument, but as I think Lord Justice Haddon-Cave pointed out yesterday, one has to look at what the text is rather than the labels, and the balance that is struck is between loss or damage caused by matters within their direct control, such as seaworthiness and manning of the ship at the commencement of the voyage. So, although it's labelled commercial fault, it includes matters such as seaworthiness and manning of the ship at the commencement of the voyage, contrasted with loss or damage due to other causes, including the acts or omissions of the master and crew during the voyage. In terms of the substance, it's an entirely orthodox analysis, and one can't have the analysis driven by the, in my submission, unhelpful labels that have been applied. For completeness, the actual decision in the Tasman Pioneer, which is that barratry is an exception to the 4.2 exceptions, wasn't followed by the Court of Appeal in this jurisdiction in the Lady N case.
In the
Lady N case. Under Mike. Lords, unless I can assist you further, those are my submissions in relation to the appeal, the appellant's notice.
Yeah.
I'm going to address you then very briefly in relation to our respondent's notice. We've got 2 points. The first is that on a fair reading of the judgment, there is a finding that in fact there were systemic failures in relation to passage planning, and that the vessel was unseaworthy because passage plans were habitually defective. As I understand, in our friend's case, he accepts that if there is a systemic failure, then that would constitute unseaworthiness. So, is there a finding that there was no proper system? We say that the way in which the judges analysed the issues is by reference to the way in which we put our case on causative unseaworthiness in our closing written submissions. What I would invite your lordships to do is to have open both the judgment at tab 7 of the core bundle and my closing submissions, which are in the supplemental bundle at tab 13. And paragraph 70 under the heading E, causative unseaworthiness. Section E, I set out the main heads of unseaworthiness that we relied on, and then in the later sections developed those in more detail. The main part of the judgment deals with 70 subparagraph 2, which is the allegation that there's no proper passage plan or passage planning process, and the master and or second officer habitually failed to produce proper passage plans. And I say that the judge followed the scheme of this section because as I say, the main part of his judgment deals with what is 72. Then after he has dealt with that, if one goes to page 104 of the core bundle, and paragraphs 116 and following, the judge's headings essentially mirror my submissions. So you've got 6274 not on board, then the working chart not updated, over-reliance on ECS, bridge management, incompetence and fatigue. So he works his way through my structure. And so the main part of the judgment, therefore, is dealing with 70 sub 2, no proper passage plan or passage planning process, and the master and or second officer habitually failed to produce proper passage plans. In my submission, it would be surprising if, obviously working from that section as a template, the judge didn't provide answers to all of the allegations that were made there, including the allegation that the master and second officer habitually failed to produce proper passage plans and there's no proper planning process in place. It'd be surprising if a very experienced trial judge simply failed to make a factual finding in relation to one of the allegations that was made in the section that he was working from. And we say that there is a finding in relation to the systems or habitual failure point in paragraph 86 of the judgment. He deals with the argument that the owners had submitted that a one-off defective passage plan did not amount to unseaworthiness, and he addresses that by reference to McFadden. At the bottom of paragraph 86, he says, furthermore, whilst the lack of proper systems can render a vessel unseaworthy, counsel submission by concentrating on the carrier's own actions to the exclusion of those of the servants or agents confuses the issue of seaworthiness with the issue of due diligence, which is non-delegable. And then he says, in any event, so having just referred to the systems argument, he says, in any event, the defective passage plan in this case was probably not one-off. The same defect was probably present in the March 2011 voyage. See paragraph 74 above. And I say that on a fair reading of the judgment, that is a factual finding upholding the second part of my paragraph 72.
Isn't another reading of it is the judge was simply using this to head off the claimant's one-off point. Wasn't making a positive finding that there was a systemic failure. Is the other way of reading this paragraph. He was simply saying it wasn't one off here, it was at least two off.
Well, if you read the two paragraphs together, 74 and 86, I think it's very hard to take it as far as you seek to take it. But I mean, the real point, you don't need this point because you've demonstrated by reference to any number of authorities that the one-off point isn't an answer to either unseaworthiness or lack of due diligence.
Yes, that is the central point. It's why
because it's a non-delegable duty.
Yes.
The fact that the master only does it once or the chief mate only does it once is neither here nor there.
Neither here nor there. That
It either is unseaworthy in relation to the and lack of due diligence in relation to that voyage, or it isn't.
Absolutely.
So this point doesn't really seem to me to be necessary.
It's if your lordships are with me on my primary point that a one-off failure is sufficient to render the vessel unseaworthy, and in my submission that is absolutely clear on the highest of authority. Then I certainly don't need this point. As I say, in my submission, it would be surprising if an experienced judge had not made a factual finding on a specific allegation that was made, and that's why I say that these paragraphs on a fair reading should be read as a factual finding to that effect. If they are not a factual finding to that effect, the case that we set out in our skeleton argument and in the respondent's notice was that you should then determine the Volcafe point of law in relation to burden of proof and determine the case on the basis of the absence of any finding of fact on the system's point. On reflection, given that the judge did not purport to decide the system's point, if he decided at all, on the burden of proof, we came to the view that that would not be an appropriate course for for this court, the appropriate course would have been to remit the case to the judge for a finding, rather than deciding the case on the burden of proof in circumstances.
Well, if this point ever became a live point, it seems to me we'd have to remit.
Yes, exactly. So that's
because the Volcafe point doesn't address Article 3.1 and Article 4.1.
no. So that's why I haven't argued the Volcafe point, because on reflection it seemed to us that in fact it's not a case that could be decided on the burden of proof, because the judge hadn't purported to decide it in that way. And remission, if you're against me that there's no finding of fact, and if you are against me on the main appeal, then in my submission, remission would be the right approach. I don't for a moment shy away from the arguments that we've set out as to why the judge was wrong in relation to Volcafe and its impact on the received wisdom in relation to burden of proof under 3.1. But that is not a point that your lordships need to decide, because it would not be appropriate to decide this case on the burden of proof.
Yeah.
So you want to save that in case it is remitted, and the answer is, well, I can't say one way or the other.
Yes, exactly.
Yes.
I hope that is many
Interesting
hoops down, or hurdles down the road that we don't have to cross.
Interesting argument for another day, I think.
Yes, but I just wish to make it clear
No, I understand.
that we do not say that the argument that we set out in our skeleton argument is wrong. We say that it's not an issue that this court has to decide, because it would not be appropriate to decide this case in this forum on the burden of proof. And then my last point is the very short one, which is that if it were right that there was some conceptual distinction between passage planning and chart updating, such that passage planning in some way fell out with the scope of 3.1, we still win, because the chart wasn't updated. The judge dealt with this at paragraph 116. He says, improbable that the notice to mariners was not on board. The systems for having it on board seem to be sound. It's true there's no documentary or contemporary evidence that it was on board, but the issue was initially not pleaded and was raised for the first time by Captain Harton's report. That's relevant when considering what inferences can be drawn from the absence of any documentary reference to it being on board. So that was a point that the vessel was unseaworthy because the notice to mariners wasn't on board at all, so it's separate from the chart updating. Then I've also noted that account does not appear to have been taken off its terms. However, this allegation, in terms of causative fault, adds nothing to the allegation that there was an inadequate passage plan. So what I say there is that it relates to 71 in my submissions, that no copy of the notice to mariners was on board. There was a failure to pay any heed to it and a failure to correct the working chart to reflect it. If one looks at the findings of the judge as a whole, plainly there was a failure to correct the working chart to reflect the written warning. And if for some reason passage planning were to be viewed in a different category to charts, then we win under a charts label rather than a passage planning label. We of course say it's an entirely artificial distinction, and that there's no basis for the submission that the writing of the warning on the chart is. My learned friend's submission is that the writing of the warning on the chart has to be analysed as either updating charts or passage planning. It can't possibly be both. And I say that's.
Well, it goes back to the last sentence of paragraph 70 and paragraph 73 earlier in the judgment, isn't it?
Yes. Absolutely goes to that. This is a case where there was a chart on board and a necessary warning wasn't written on it.
Yeah.
In terms of it's got to be one or the other, that's wrong, because
your point about labels, and it's not the label, it's the
outcome.
substance of the
Yes.
relevant breach that
Yes.
matters.
But also to say that updating charts is one thing and passage planning is something completely different, and any task has to be allocated to one or the other. It exist in both camps is plainly wrong when you look at the guidelines, as I took you to yesterday, where the appraisal stage involves making sure that you've got all the right materials in front of you before you start planning the voyage.
It may be a necessary step in passage planning to make sure that you've updated the relevant chart and the relevant
Exactly.
bit of it, as we discussed yesterday.
Exactly. That's exactly the way in which I put it. Look, unless I can assist further, those are the submissions I want to make.
Thank you very much, Mr. Yes.
My lords, we've been thinking overnight how best to assist your lordships in presenting, our reply submissions, because there's a having heard my learned friend for an hour and a quarter yesterday, and he's just repeated it now, there's a particular order in which you have to ask the questions, and a particular order, and a particular questions that you have to ask are important, and the wording is. So what we've done, which we hope will save your lordships having to take, as it were, dictation this morning, or this afternoon now, is reduced into a few pages, the questions and the answers, as it were, which I hope will assist. If I can hand that up. A couple for my learned friend. I'm grateful. My lords, today, my lords, my learned friend has gone through his authorities for most of the morning, and I handed out to your lordships yesterday a table which we hope was assistance, because it sets out our response to the propositions and to the cases, and why we say they're either accepted propositions or not relevant. We hope that will stand, as it were, to the response to a lot of what has been said this morning. What I want to do is just go back on the first 3 pages, deal with basically the first hour yesterday, which is this point about charts and whether or not the judge found that the chart had not been updated, because I sensed from yesterday's interventions from the bench that the bench felt that the chart hadn't been updated. Now, we say there's 2 distinct aspects.
No, because it's not. The point is that the charts did not contain the warning. And the judge has found at paragraph 70 and 73 that the charts did not contain the warning in the notice to mariners, and that rendered the vessel unseaworthy. How you label that, whether you say it's part of updating, or whether it's part of passage planning, or it's part of ensuring the vessel's seaworthy, doesn't seem to me to make any difference.
With respect, my lord, our submission is it does make a lot of difference, because you'll see in a moment it'll come to the question of attributes. And can I say at the outset, just so that you have this in mind, Article 3, Rule 1b requires you to have, to make a vessel seaworthy, proper equipment. And charts are part of your proper equipment. So that's what. So if one's saying it's charts that were defective, then of course it goes to attribute. Of course it goes to the attribute of the vessel. It's her equipment. If you look at passage planning, as you'll see in a moment, we say that's not an attribute of the vessel. That's why this distinction between updating charts or not updating charts is actually very important. And your lordship, Lord Justice Faux said earlier to my learned friend, it doesn't mean we're going to duck the question, as it were, on attribute and passage planning, but it does focus that question.
So tracing over what's in 1691 oblique-stroke 11 is updating, and therefore part of it, if you don't do it, it renders the vessel unseaworthy because it goes to an attribute of the vessel.
Equipment,
but
yes.
Not writing the warning,
Absolutely.
which means that the vessel cannot
And the next 3
sail
pages.
safely, is not part of the attributes and not unseaworthy.
Absolutely, and the next 3 pages will explain why.
Okay, very good.
My lord. So there's 2 distinct aspects of charts, as we say here. The chart itself, you have to have a chart of appropriate scale, accurate and up to date, and that's on the guidelines we looked at yesterday. Owners say that this is this is the chart you received from the UKHO if you bought a new chart for delivery on board on the 17th of May, the day when the passage planning was done as she leaves the berth. In that regard, the chart on board the Libra was not defective in this regard. It was the appropriate scale, it was accurate, and it had been updated, corrected. And that was found by the judge in paragraph 64, where he says that the legend, do you remember the legend on 6275 required the legend to be amended on the chart, and that had been amended on the chart. And also he finds that paragraph 117 that the notice to mariners 1691 had been done and it was updated, and that was actually a ground of appeal. We say that's the first aspect. The second aspect is annotations added to the chart, and these are added as part of passage planning. Now, we say the judge did not find the chart had not been updated due to the notice of mariners in this regard. And in paragraph 19 of his judgment, he sets out what the three notice to mariners are. Then it's 19, 20 and 21 were the three notices of mariners. And then in paragraphs 59 to 74, the judge deals with the criticisms of the passage planning, and it's under that precise heading, and it's important, passage planning, criticisms of the passage plan. In paragraph 75 to 114, he considers the passage planning in terms of seaworthiness, causation and due diligence. And then in his judgment at 116, and then you'll see by 114 he holds the vessel was unseaworthy because of passage planning. On 116, he says, as you'll see, there was no suggestion that the notice of mariners was not on board. He then says that the allegation, he says this allegation has nothing. That allegation is I have also noted that the account does not appear to have been taken of its terms. That's not a finding at all, we would submit, my lords, that the chart hadn't been correctly updated and corrected. It's a reference back to passage planning. And then you'll see actually the next paragraph in 117, he deals with the corrections to the chart, updating and corrections, and he finds that they were done. Now, my lords, then in 129, you will see that the only basis upon which he concludes the case against my clients is that the vessel was unseaworthy before and at the beginning of the voyage from Xiamen because it carried a defective passage plan. Now, interestingly, I don't take a pleading point. My paragraph 2.7. This was, if you look back in the pleading, this wasn't actually a pleaded case. And also we say, with respect, my learned friend's approach to chart updating and correction misunderstands that process. And we say the judge rightly considered that the annotations to the chart were part of passage planning, and that's important. We can test it this way. If owners had not engaged chart suppliers to provide the notices to mariners, but instead had a system of sending a new chart published by the Hydrographic Office every time the vessel was in port, then the vessel would have received that very chart you see in the colour chart in tab 5 of the supplementary bundle. That would have been the chart of the appropriate scale, accurate and up to date. Now, next bits are quite important, my lords. The judge heard expert evidence and he concluded that the chart should be annotated as part of passage planning. That the chart was not so annotated meant it was defective as a matter of passage planning. However, it was the correct chart that had been correctly updated. And we say in paragraph 3.3, the judge's preference for a warning on the chart rather than hatching a no-go area was a judgment by him after the hearing contested their evidence. Another judge, for example a judge in the US, may take a different view and prefer hatching, like Captain Hart did in this case. A third judge in Australia might take the view that neither hatching nor a warning was necessary, and it was sufficient to have the notice to mariners clipped to the chart like Captain White believed. Chart corrections and updating do not depend on such differences of view, however reasonably held. it is agreed that the judge found on the facts that the chart had not been properly annotated as a matter of passage planning, and owners, we do not seek to go behind that finding of fact. But it cannot be extrapolated into a finding of fact that the chart has not been corrected and updated. Chart corrections do not depend on exercise of good seamanship and do not depend on varying professional views as to what is necessary.
But before we get tied up in whether it's to be regarded as updated, isn't the finding of fact as simple as saying that in the form in which the vessel had it, the chart which they had when they set sail to leave Xiamen was not safe to use for a vessel departing the port?
No, with respect, my lord, I would say that the chart was the correct chart and safe to use, but the navigational decisions and the passage planning process had been done defectively.
For the form in which they had it, the document they had was unsafe.
No,
Isn't that what the judges found?
The chart was perfectly safe. The chart was also part of the passage planning process and documentation, and the passage planning had been inadequately done, such that it could have been hatched, but this judge said it should have had a warning at the top. That was part of the passage planning process.
Well, whether it was part of the passage planning process or not, the effect of paragraph 70, last sentence in paragraph 73 of the judgment is exactly as my Lord, Lord Justice Mayles has just put to you. That the chart in the form in which it was did not contain the warning and therefore was not safe.
Well, my lord,
rendered the vessel unseaworthy.
What it is.
So fine points about updating of the chart don't seem to me to take you very far.
Well, in
Sure, it is. Different judges might have taken. A different judge might have decided that they should have, in fact, have put in no-go hatched areas. But
well, my lord,
either way, the chart was defective.
in paragraph 73, what the judge said is, in the present case, neither the passage plan nor the chart contain the necessary warning. It was therefore defective or inadequate and imprudently so. But you have to read that in the context of paragraph 70. And in the context of paragraph 70, he uses passage plan to actually mean passage plan pro forma and the working chart, and together they are the passage plan. And one gets that very clear from the last 9 lines of paragraph 85, which we haven't really focused on.
Sorry, which paragraph was that?
85.
85, thank you.
And the last 9 lines, we say, of paragraph 85 make it clear beyond doubt that the updating and the correcting of the chart did not require the warning of a no-go area to be placed on it. That was part of passage planning. And that is important. Now,
Well, the judges found that the passage plan was defective in 2 respects. One is the actual plan itself didn't contain any warning, as in the written plan that we had in the bundle. And 2, that the chart did not contain the warning on it, and therefore the whole process was defective in those 2 respects.
I agree, the passage planning
That amounts
process.
to, he finds at 85, an attribute to the ship, in the same way as a failure to update the chart.
And now I'm going to come on to that. And it's on my page 3, attributes of the ship. We accept for the purposes of this hearing that the absence of appropriate scale and accurate and up-to-date charts is an attribute of the ship. And as I just said, that's because of Article 3, Rule 1b, it's equipment. What we say is the absence of annotations from a chart, which are required as part of passage planning, does not affect an attribute of the ship. They are navigational decisions in and of them, and the reason is navigational decisions in and of themselves cannot be an attribute to the ship. They are navigational decisions that are taken by navigators in respect of the ship. A navigational decision can subsequently affect the attributes of a ship, and we accept that. Consider the crack in our example of the shell plating when a vessel bursts alongside a quay too heavily. In those types of cases, the navigational decision is just part of the causational background and does not inform the character of the defect, and that's crucial. A passage plan is the recording of navigational decisions. See again our supplementary skeleton on the 4-stage work process. recording those navigational decisions in a document does not change the legal nature of the navigational decisions and does not change those decisions into a defect in the ship. Therefore, we say a defective passage plan comprises one or more defective navigational decisions. These cannot be attributes of a ship. And we say that's why we go back and say the fundamental distinction then is between, on the one hand, there being on board everything required by the crew to navigate safely, and on the other hand, the actual act of navigation by the crew. An owner is responsible for the former, but not the latter. The latter is within the domain of the crew as navigators and falls within the fundamental exception of Article 4 of Rules of Now,
Mr. Hill, before you go on,
yes.
the mere fact that a tracing may have been done and a reference to a notice to mariner put on coloured chart doesn't necessarily mean that that chart is safe.
I would agree with you that as part of the passage planning process, you would need to.
Well, forget about passage planning process. I mean, we understand your case, constantly telling us passage planning is not to do with seaworthiness, but just focus on the point my Lord's making, which I think is the same point as I put you a moment ago. This chart was unsafe.
I was in the
Because
process
it
of
didn't have a
answering
warning on
my
it.
Lord's question.
But if the chart was unsafe because it wouldn't have a warning on it, why doesn't that render the ship unseaworthy?
It's not unseaworthy because that, my lord, doesn't go to an attribute of the vessel. It's a recording of the navigational decisions of the navigators. The navigational decisions aren't an intrinsic attribute of the ship. They are, if anything, the decisions of the navigators on how they are going to navigate. It goes nothing to the intrinsic attributes of the ship. That is why you do need up-to-date charts. You do need the latest version that have been corrected. Then you use those charts to navigate. And if in the process of navigating you do not conduct a proper passage planning and you make wrong navigational decisions, the navigational decisions are not an attribute of the ship. And that's a big distinction.
This is a submission you made at some considerable length yesterday. Can I just ask you this? Mr. Russell suggested yesterday, I think, that if on the notice to mariners it had said you must write this warning on the chart about the various depths not being reliable, do you accept that if the notice to mariners had said that, the failure to put the warning on the chart would amount to unseaworthiness?
I accept that.
Would be an attribute of the ship.
I accept that if there is a notice of mariners that says this chart should have been updated by placing this warning on the chart, such that if you bought it new from the hydrographic office, it would have had that warning on the top, then it's not been a corrected and updated chart. Yes.
The interesting thing about this notice to mariner, which you'll find in the supplementary bundle at tab 6, is that it contains a plethora of information and a very troubling warning about numerous depths being less than charted. So it may be that when updating the chart, there is a seamanship judgment to make. Actually, just referring to NM 6274P is not enough.
My lord, the difference
I need
is.
to put more on it to make, leaving aside passage planning, I need to put more on the chart.
Well, that's where, with respect, we say the analysis breaks down. It's not a question of updating. You've got the correct chart. The chart has been correctly updated. This is now a judgment issue on passage planning and navigation. These are navigational decisions that aren't in any sense intrinsic or attached to the vessel. They are just navigational decisions as to when you navigate, how do you navigate safely, and should you put certain warnings on the chart because you're going in a certain direction. And that is because you're doing that voyage, and different people will have a different process of how they're going to do it. And it doesn't mean there's anything wrong with the vessel. the vessel is fine. The problem is, or as the judge found, he did not like the way, the navigational decisions made by this master, and in particular, he did not like the way this master had planned his navigation by not hatching or the chart or putting on the warning. Well, also, I've got very limited time now. I've got, if I can just very briefly run through these following points. Temporal distinction. There have been two temporal distinctions advanced by cargo interests in this case. The first is in relation to Article 4, Rule 2, and it was addressed in 103 of my learned friend's skeleton argument. It's no longer advanced by cargo interest. It was based on the Kalima, which was superseded by the US Causational. And that's clear, and you get that, my lords, also. Can I just ask your lordships to write down a reference? It's page 4 of the Jalavia case, where they say exactly that. The old Harter Act had a different rule. The second temporal distinction is Article 3, Rule 1. And we say, my lords, acts of navigation are treated in exactly the same way before and after commencement of the voyage, unless they concern the attribute of the ship prior to the commencement of the voyage, in which case they may be capable of rendering the vessel unseaworthy. So I don't disagree at all with the point my Lord Haddon-Cave makes, because I accept that. We say the legal character of the act is the same before or after commencement of the voyage. It's an act of navigation. This now appears to be common ground. And we say this: if it's correct that it is correct that if the vessel is unseaworthy prior to the commencement of the voyage, then it does not matter whether the reason for this is a prior error in navigation or management. However, there is an intermediate step. The navigational decisions must be an attribute of the vessel the navigational decisions must be an attribute of the vessel if they do not result in a change in the state of the vessel. Now, that's the point I've just been making in the last 5 minutes. However, pure navigational decisions are not attributes of the vessel, see above. So when the navigational decisions lead to change in the state of the vessel, for example, a crack in the side shell plating or grounding, then the navigational decision is just part of the causational background and does not inform the character of the defect. And then we can wrap up my learned friend's cases today on management. Similarly, decisions of management of the ship do not in of themselves amount to an attribute of the vessel and cannot without more render the vessel unseaworthy. But decisions of management of the ship can subsequently affect an attribute of the ship. The managerial decision in that situation is just again part of the causational background and does not inform the character of the defect. And we give you the example based on the EVSU. Master informs the managers ashore that he needs 2,000 metric tons of bunkers to sail across the Pacific. When that decision is made and communicated to the managers, this is not an attribute of the vessel, and she's not in an unseaworthy condition. It's only when she takes on 2,000 metric tons of bunkers and the vessel departs with no more bunkers that she is unseaworthy, as now she has insufficient quantity of bunkers on board, and it's an attribute of the ship. The decision of management by the master is just part of the causational background. It does not inform the character of the defect which renders the ship unseaworthy. So we say, thus in the management cases relied on my learned friend and the court's own examples, FG, the lack of bunkers was an attribute of the ship. For example, Article 3, Rule B, properly supply. The Friso, the crew's managerial decision in failing to press up the double bottom tanks affected an attribute of the ship. She was unstable for the anticipated voyage. The court's example of improper trim, ditto. And the court's example of not battering down the hatches. That the vessel was not tight, staunch and strong for the anticipated voyage. It goes to the attributes of the vessel. Now, my lords, just to conclude, navigation, therefore, when a master makes a decision at berth, so before he's left, to take one route rather than another on an anticipated voyage, for example, to go up the Mozambique Channel towards Somalia rather than go east of Madagascar and through the Indian Ocean, this does not become an attribute of the vessel, and the vessel is not unseaworthy. She's not in an unseaworthy condition. The fact that the master may record it on his chart does not change the legal character of the decision and does not put the vessel in an unseaworthy condition. And the same applies if the route is written into a formal passage plan pro forma document. The ship becomes unseaworthy when she's attacked by the pirates. So going to this appeal, the same analysis applies on the facts of our case. A decision to take the wrong route is no different from any other navigational decision with respect to how the vessel will be navigated during the voyage. Although the decision was taken prior to the commencement of the voyage, it does not lose its legal character. It is not an attribute of the ship. And it's no answer, we say, that the written passage plan is in preparation for navigation, which is the point my learned friend keeps making today, and not navigation under Article 4.2a. This is to reintroduce the old and discredited and illogical distinction between navigational decisions before and after the commencement of the voyage.
I don't think he did, with respect. I think Mr. Russell's point was that this was preparation for the voyage, preparation to make the vessel safe for the voyage.
It's the same point, my lord,
No,
because
it's a different point. But I follow your point about preparation for navigation.
Yes, my lord.
But
So,
I think you're tilting at the wrong windmill, with respect.
well, my lord, you have my submissions. What this appeal really turns on for your lordships, and it's going to be very helpful for the industry and lots of people, which is what is unseaworthy? What is an act? Do you apply the McFadden test to any defect, or does it have to be a relevant defect? What is a defect? Does it have to be an attribute of the vessel? What is an attribute of the vessel? Can navigational decisions be attributes of the vessel? That's what this appeal is about. I've borrowed a lot of time from your short adjournment, my lords. I'm grateful for the time you've given me, actually. Unless I can assist your lordships any further. On my respondent's second ground on his respondent's notice, it's set out in my skeleton argument. I don't need to address it. But I'm grateful for the time your lordships have given me.
Thank you both very much indeed for your helpful submissions. It won't come as a surprise that we will reserve judgment. You'll receive the draft judgments in due course for corrections to any obvious typos, not to invite us to rewrite our judgments in the way in which you'd like them to be written. And if at the relevant time you can agree a formal order between you, no attendance will be necessary. And thank you all very much again for your what's been an extremely interesting appeal.
We'll try.